You may proceed.
Good morning, Your Honors. May it please the court, Tom Sider for the appellant, Mrs. Marinek. And if I may, I'd like to walk this court through the two issues that we raised on appeal. As you know, the first issue is that the trial court employed the wrong legal standard in ruling on Progressive's motion for new trial. And the second issue is that the trial court erred under any standard in granting a new trial on the basis that the verdict was excessive. I'd like to start, if I may, with that second issue because it is the more factually intense of the two, and also because, to the extent that the trial court grants the relief we're asking for, which is reinstatement of the jury's verdict, it does obviate the court's need to even look at that first issue. The second issue on appeal does involve the trial court's discretion. The abuse of discretion does apply, and it is afforded to the trial court. But that discretion does have limits. A court can't order a new trial on grounds not supported by the record, on an objection that was withdrawn or unpreserved, or that was never raised in the first place. And here the trial court did all of those things in finding that two categories of damages were excessive: non-economic damages and also future medical expenses. And I'll start with the future medical expenses, which Mrs. Marinek proved at trial using the testimony of an expert life care planner named Dr. Gandhi. Now, the first finding that the trial court made that we submit was error is the trial court found that Dr. Gandhi's testimony was unreliable or should not have been allowed because he relied on this online database of private healthcare claims. Now, we disagree on the merits. We think it was entirely proper for him to rely on this sort of information, but it is rather beside the point here in that the trial court, seemingly forgot that Progressive had withdrawn its objection to that testimony on this basis. Before, on the first day of trial, Progressive had moved to exclude this testimony, saying that Dr. Gandhi was improperly relying on this supposedly improper information. But when it became clear that the trial court was contemplating granting the motion, and that also the trial court was thinking it was going to continue the trial, Progressive withdrew the objection and said, I don't want to raise it anymore. I want the trial to go forward. That is, a calculated risk that Progressive took. It affirmatively withdrew its objection. And as a result, it should not have been able to move post-trial to set aside the jury's verdict on the basis that this testimony was supposedly improper.
Mr. Sider, I didn't see in the record where there was an argument about the admissibility of his testimony based on a website. I know that there is a brief scant motion in limine with one paragraph, but was that ever argued before the court and ruled on?
It was never ruled on, Your Honor. It was discussed right before trial began.
Well, then let me ask you a question, because I haven't seen a case like this before where a court grants a new trial and within the order, it concludes that it would have excluded a witness that it allowed to testify when it had not conducted any type of hearing concerning the admissibility of the witness's testimony. Is there a case out there? I mean, because it seems to me, one could arguably say that's non-record evidence. The court has based its decision on, because to grant a new trial, the court has to weigh the evidence, correct?
Correct, Your Honor. And I don't think there is a case that is squarely on point here. This issue was argued briefly before trial began, and that's when Progressive said that it was improper. There wasn't any sort of Daubert hearing or anything like that. And importantly, the trial court never did make a ruling.
Did either party ask for a Daubert hearing?
Not that I'm aware of, Your Honor, no.
So was the court, sui sponte, brought up a Daubert hearing in the order?
Yes, Your Honor, that's my understanding. Or at least there's nothing in the record to suggest that either party suggested a Daubert hearing. And as you said, the motion to exclude Dr. Gandhi's testimony was one sentence long, and it certainly didn't make any arguments about Daubert or request a Daubert hearing or anything of that nature. But even if Progressive had done all of those things, once Progressive withdraws its motion and says that it doesn't want the trial court to rule on it, Progressive is has waived that forever. Even fundamental error is waived and cannot be a basis for reversal if it is affirmatively withdrawn by the moving party, which is what happened here. And so, I think that the trial court's reliance on this supposed improper basis for expert testimony, it absolutely cannot be a finding supporting a motion for new trial or an order granting new trial. And that is a reason to reverse the trial court's order all on its own.
Well, but there does appear to be some objective evidence the court does base its decision on: minimal property damage, no emergency medical treatment. She didn't comply with medical recommendations and treatment. There's a 2-year gap in treatment. She birthed a healthy child. There's no claim of lost wages. There's 25 grand in past meds. Life care plan based on 25 grand in past meds is $405,000. In future medical expenses, past pain and suffering, $245,000. Future pain and suffering, $1.5 million. When the court found that she didn't follow up with treatment, although she did have 2 children, I believe, in the interim. But that's not enough objective evidence?
Well, no, Your Honor, not when the trial court is premising its order, is granting a motion for new trial for reasons not supported by the record. I understand that there are, some bases in the record. We would dispute quite a few of the trial court's findings, but once we can establish that the trial court relied on this improper basis in granting a new trial, the order can't stand, would be our position. There is no sort of harmless error analysis that I'm aware of that you can, or tipsy coachman analysis you can do when a trial court errs as a matter of law in articulating the reasons for reversing, or rather doing away with a jury's verdict. And there were other problems with the trial court's findings as to the future medical damages. As you mentioned, Judge Sleet, the trial court seemed to take issue with Mrs. Marinek's treatment history. That was a driving force here for the trial court. And what the court said is that because she didn't receive treatment in the past, it's not likely she's going to receive it in the future. The problem here is that Dr. Gandy knew about her past medical treatment and gave his opinion, nevertheless, that he thought there was going to be future medical expenses, that he thought she was going to need this future medical care. The jury relied on that testimony. And so when the trial court here is saying that the jury returned a verdict against the manifest weight of the evidence, what the trial court is saying is that the jury, by failing to reject unrebutted expert evidence, returned a verdict that was manifestly weighted again, or was manifestly against the weight of the evidence. And that can't be how the manifest weight of the evidence standard is supposed to work. It can't just be that the trial court would have decided the case differently.
Did Dr. Gandy also treat your client?
Yes, Your Honor.
That's kind of out of the norm. Life care planners aren't treaters.
Yes, Your Honor. He's also a physiatrist.
So he actually treated her and then also developed a life care plan.
Yes, Your Honor. He did treat her. He had a few appointments with her, and then came up with the healthcare plan. Yes. And so in this case, Progressive doesn't put on any evidence about what future medical care is going to be reasonable, doesn't introduce its own healthcare plan, and really doesn't make much of a case at all, and doesn't even suggest an alternate figure to the jury for what future medical expenses would be reasonable. And so it's not really a surprise here that what the jury ends up doing is accepting the only expert evidence that it has in this case, which came from Dr. Gandhi. And I do want to highlight, Progressive admits this in closing arguments. Progressive says, page 807 of the transcript, so in this case, the only information that you have for question number 2 is going to come from Dr. Gandhi. Now, Progressive asked the jury to ignore that evidence, but that doesn't, just because the jury could possibly decide that they didn't want to accept Dr. Gandhi's testimony, doesn't mean that the evidence was manifestly weighted in favor of Progressive. And if anything, the evidence here was manifestly weighted in favor of Mrs. Marinette. because again, we're the only ones that presented any sort of expert evidence here. And really, at most, what we have here is disputed evidence and not manifestly weighted evidence. And as this court held in the Farmore case, which we cite in the briefs, a trial court can't, under these circumstances, act as an additional juror in determining an essential issue based upon what, at most, was conflicting evidence and not evidence that was manifestly weighted to one side or the other. That's exactly what the trial court did here, which is why we submit that the award of future medical expenses needs to be reinstated and the trial court needs to be reversed. I do also want to discuss the non-economic damages. The trial court, again, with this category of damages, raised sua sponte two factual issues that had never been raised by the parties in the case. And it did so because it was trying to articulate ways in which the jury may have been prejudiced or may have looked to evidence outside the case in coming in reaching its verdict. And the first thing that the trial court said was that Mrs. Marinek made references in her testimony to her church or religion, and the court is concerned that these remarks were designed to curry some type of favor with the jurors as they bore no other relation to the pertinent facts and issues in the case.
Were there any objections to that testimony?
No, Your Honor, there were none. Not during the trial and not post-trial either. This was not something that Progressive raised in its motion for new trial. It was not mentioned at the post-trial hearing. It appeared for the first time in the trial court's order granting a new trial. So not only is there no record support for it, and not only is it unpreserved, but it's been raised sua sponte, which takes away Mrs. Marinek's ability to explain to the court why this view is incorrect, why she wasn't trying to curry favor with the jury.
On at least one of those occasions, it related to where she was leaving on the way to the event, correct?
That's correct, Your Honor. So there were two mentions of her church, and one was she was asked to just describe her morning leading up to the crash, and she said, I was going from church to the Rays game, and the Rays game got much more mention than the church in that narrative. And then the other time was she was describing her relationship with her husband. She does have a consortium claim in this case, or says that she has a loss of intimacy. And all she said was, I met my husband at church. That's it. And so those two passing references to church certainly are not evidence that Mrs. Marinek was trying to curry favor with the jury. They don't show anything that would be, cause the jury to become impassioned or emotional or inflamed. And that is probably why Progressive didn't object, didn't say anything about this. And even now on appeal, doesn't try to defend the trial court's reasoning, doesn't try to say that, oh, this might have been something that impassioned the jury. Throughout, this has been something that only the trial court has raised and only the trial court has seemed concerned with. And the same thing is true for this aside about Mrs. Marinek's former boss, Mr. Deason, who came in and testified. The trial court felt like he had this sort of outsized impact on the jury. Again, nothing in the record to support it, was never raised, and was not argued post-trial, something that the trial court put in its order for the first time when it issued the order. And for both of these, in sua sponte raising these issues, there's a due process problem, and there's also the problem of when a trial court starts to raise and adjudicate issues on behalf of one of the parties, it raises concerns of partiality. And we have that here too, on top of all the other problems having to do with an order that's not based on record evidence and is ruling on unpreserved objections. The other non-economic damage findings that the trial court makes are also unsupported by the record. This is an area where the trial court is supposed to be very deferential. The trial court is supposed to, understand that the jury is inherently dealing with something that can't be quantified. We didn't see that sort of deference here. The trial court made a lot of findings that were either, contradicted by the record, or that missed parts of the record, or that mischaracterized the record. So, for example, one of the things the trial court says in the order is Mrs. Marinek, she wasn't as badly injured as the jury must have thought, because she was able to continue all of her employment duties after the accident. but she was not. There was evidence in this case that she struggled terribly at work after the accident. The trial court said she missed no time from work. That's not true either. That she did miss time immediately after the accident, and she missed time repeatedly because of doctor's appointments. It became a real problem at her job. The trial court said there was no evidence she might require surgery. There was evidence that she might need surgery, although we didn't seek future medical expenses for future surgery, but we did have expert testimony saying it's very possible rather that she'll need surgery in the future. The trial court also said she could do everything now that she did before the accident, except for some recreational activities, some activities with her children, and lifting heavy objects. But the
You're
evidence
at 15 minutes. You can use it any way you like, but I just wanted to alert you at 15.
Thank you. I appreciate that, Your Honor. I'll try to wrap up pretty quickly. I just wanted to point out that the evidence showed more limitations than that. Mrs. Marinak testified that she's in constant daily pain. The trial court's order does not mention that. Mrs. Marinak said that she can't sleep at night. She loses almost 2 hours a night from sleeping in her estimation. The trial court didn't mention that. She has trouble being intimate with her husband. That's also not mentioned in the order. And then, the order says that she has trouble with some heavy objects, some activities. That really does undersell things. She can't carry her own luggage. She can't do basic household chores, and she can't even pick up her 18-month-old son. And she gave very affecting testimony about what a big deal that is to her, not being able to pick up her son, not being able to play with them or bathe them or take care of them in the way that she always thought she would be able to. And I guess the last thing I'll end on before I reserve the rest of my time is the jury's verdict here was not just for a decade or two. Mrs. Marinak was 33 at the time of the accident. She was 36 at the time of trial. Her life expectancy was an additional 46 years. And so the jury's verdict, the non-economic damages, when you stretch them out over that 46 years, it was not clearly excessive, and it did not show any type of passion or prejudice on the part of the jury. And so I'll reserve the rest of my time if I may.
All right, sir. You have 4.5 minutes.
Thank you.
Good morning, ma'am.
Morning. Thank you, and may it please the court. The trial court is presumed to have drawn on her talents, her knowledge, and her experience to determine if the verdict was against the manifest weight of the evidence. It requires a clear showing of abuse to overturn, and that's based on a reasonableness test. Specifically, the trial court's decision, was the trial court's decision reasonable? And if so, it will not be overturned. The appellant is asking this court to reweigh the evidence submitted to the jury in the trial court's place, and that is not the test. The Supreme Court has stated that an analysis of the evidence supporting the jury verdict isn't relevant to the review of an order granting a new trial. Simply because there's evidence in the record which would support the jury verdict is not enough to show abuse of discretion in granting a new trial. The focus is not on the evidence that supported the jury's verdict, but on whether the trial court's decision as outlined in the order was reasonable. And abuse of discretion must be clear from the record to overturn the order. In making its decision, the trial court must consider the credibility of the witnesses along with the weight of all of the other evidence in reaching the determination of whether the jury has reached an unjust decision under the facts.
Let me ask you about Dr. Gandy.
Sure.
Because the motion in limine was never heard. You agree with that?
Yes, Your Honor, I do agree with that.
So the admissibility of his testimony was never adjudicated pre-trial, correct?
Correct.
Okay. This trial court put in the order that she would have excluded his testimony if given the opportunity. She was never given the opportunity. That is sui sponte injecting non-record evidence into a decision to grant a new trial, is it not?
So, Your Honor, Progressive would...
Yes or no?
No, I don't agree with the analysis. And
okay, so what evidence did she have before her, the legal basis for excluding his testimony?
So it's the premise that I disagree with. I don't believe she excluded his testimony.
No, she said she would have excluded his testimony, meaning she didn't believe a word he said. even though the parties never argued the motion in front of her and she never ruled on it.
Well, just a little bit more background. The motion actually was heard and she did rule on it, but then the morning of trial.
You waived the motion. Mr. Hendricks
Correct.
waived the motion. There was no ruling. It's in the transcript. There was no ruling, no denial, nothing. So the court, sui sponte, brought that up, did she not?
She did raise the issue that had been withdrawn, and as far as the objection goes, correct.
Okay, so the determination of the admissibility of his testimony was not at issue during trial,
Correct.
yet it's in the order for new trial.
She does mention it in the order for new trial, but I don't
How is that
believe,
not an abuse of discretion?
I don't believe that she relied on or I guess rejected his testimony in the order outright. She actually incorporated an analysis of all of his testimony into her analysis of whether there was an excessive verdict.
But she opined that she would have excluded the only expert who gave testimony concerning future medical expenses and future pain and suffering. He was the only one.
For the plaintiff, there was an expert presented by the defense.
That was an IME, CME doc. He didn't talk about anything about future medical expenses. He didn't even talk about $1, correct?
Correct. He opined that her
He said she's not hurt.
complaints had resolved.
So is what you're saying, you would have us believe that that was just kind of dicta in the judge's order? There was no reason, just sharing with us her opinion that this expert would have been included if they'd actually gotten to that decision?
Yes, Your Honor, that actually is my position. In fact,
And there was no weight given to it at all. She just wrote that couple paragraphs about the Dr. Gott, right?
Correct. That's my opinion. And I believe that because when you look at her analysis of why the future medical expenses were not supported by the evidence, she goes through a detailed analysis of Dr. Gandhi's testimony and why she believes that it's not reasonably certain that plaintiff will incur the future medical expenses in the future, which is the required test at the trial level for future medicals. So, and she goes through it in great detail without mention of the objection or that she would have excluded him. She goes through every element that he discussed, that he suggested that the medical treatment that she received, and that is how she arrives at her conclusion that they're not reasonably certain by his testimony in conjunction with the plaintiff's testimony and the evidence with regard to her past treatment. She did not write off his testimony as though he had not been permitted to testify. And the record, it's Progressive's opinion that the record doesn't support that the court granted a new trial based on this withdrawn objection. And that it was, like you say, something along the lines of dicta. To go back to the question of the future medical care, what the court did point out is that Ms. Marinek's basis for not seeking the recommended treatment was because of her pregnancy. But if you look at the timeline, it doesn't really work. The evidence shows significant gaps in treatment, times when Ms. Marinek could have undergone any of the recommended treatment at a time when she was not pregnant, whether it be pain management, physical therapy, or chiropractic adjustments, and she chose not to do so.
When you say when she was not pregnant, are you saying immediately before the pregnancy or during the time she was breastfeeding?
Right, Your Honor. So to be clear, there was an 18-month period post-accident and when she was not pregnant. And the initial pain management recommendations were made approximately 6 weeks after the accident. And she didn't seek any of that treatment. She after her first pregnancy concluded with the birth of her son, she resumed treatment with the chiropractor in September of 2018, and in October of 2019, about a little over a year later, she had her one appointment with Dr. Gandhi. And approximately October, November 2019, she gets pregnant again. So shortly before trial, she was about 12 weeks pregnant. So you have another 11 or 12 months there where perhaps she was breastfeeding at that time, and I recognize Dr. Gandhi's testimony with regard to her ability to receive injections, and that would be counterindicated. But the evidence with regard to other suggestions by Dr. Gandhi and her other treaters was that she undergo other types of treatment, which she chose not to do. For example, sleep studies. Those are non-invasive treatment to try to resolve some of her issues, which she chose not to do. And in fact, her testimony was that in September of 2016, she stopped treating because she was tired of going to the doctor. She wanted to focus on her new job, and she wanted to get into the right mindset to start trying to get pregnant. So
yeah, but see, the jury heard all of these excuses. This isn't something that was withheld from the jury. They knew she didn't treat, but the same Dr. Gandhi who testified about future medical care said she had a permanent injury. Mr. Hendricks said that she deserves 0. Mr. Hendricks' motion for directed verdict was 3 words: did not prove their case. So tell me, the judge brings up her mention of religion and church, and it was designed to curry favor with the jury. How are we, not being there, to decide how much that affected the judge when that particular issue was never in dispute in that courtroom? Mr. Hendricks never objected about it. And then Mr. Deason, how are we to determine how much effect this had when the judge says, Mr. Deason's, and this is why you call a before and after witness, because you want to tell them how she was before and after. And the court says they thought very highly of the plaintiff after Mr. Deason's testament. Well, that's what's supposed to happen if you do your case right. But why is the court weighing in on this when it was never disputed by the parties? Never.
Thank you, Your Honor. So with regard to the question of religion and the testimony of Mr. Deason, the court didn't reach any conclusions regarding these factual issues.
Curry some type of favor is not a conclusion.
No, Your Honor, I don't believe she adjudicated any of those issues by including those facts in the order. There's no formal judgment or decision in this order regarding the evidence that it should have been excluded or...
Well, Progressive didn't seem to be bothered by the testimony, but the judge was.
Right. And so the trial court is required to outline in its order the considerations for granting the new trial, and the various points were included as support for the trial court's ultimate findings regarding the excessiveness of the verdict. The trial court is supposed to consider all that she witnessed and experienced in the trial and making her determination about whether a new trial is warranted, and she's not limited to only certain aspects.
Then it says that they gave her money because she goes to church, and they gave her money because Mike Deason did a good job. That's basically the conclusion to be drawn from here. How is that not the court's personal opinion versus an objective determination of the evidence?
Well, Your Honor, I think the court included these particular issues in the order as factors that figure into the overall determination of the excessiveness decision.
But they were
like
factors
all the
that
other
weren't
evidence.
objected to. I mean, these are issues that came in. How is this not the judge becoming the 7th juror?
So the court, in Progressive's opinion, isn't the 7th juror here because it's the trial court's job to look at all of the evidence and evaluate the evidence and the testimony and make a determination if the jury reached a reasonable conclusion based on the manifest weight of the evidence. And the court went through in its relatively detailed order the testimony about the impact of the accident on Ms. Marinek's life, the testimony from Dr. Gandhi with regard to her future treatment, the
But as Judge
testimony.
Sleet said, the jury heard all of this. They weighed it out. They made a determination. But the three issues that the trial judge really brings out before spending, I don't know, the last 8 or 9 pages talking about other cases that didn't get this much, so that it was excessive. The three issues that we have before us are the Dr. Gandhi testimony, the religion church testimony, and the Mike Deason, being a star witness. Do you agree those are kind of the three things that the court highlighted?
I wouldn't say that the court highlighted them. In fact, I think that the court spent significantly more time on the various testimony of Ms. Marinek, evaluating it as it relates to Dr. Gandhi's testimony and the testimony from her other treating physicians with regard to the treatment she had undergone. I think that she mentions the question about, I think the question about Mike Deason, or the statement about Mike Deason, was maybe a paragraph, and the religion mention also the same. I think she also goes through quite a bit the work history, the fact that Ms. Marinek had not been, she wasn't making a claim for any past lost wages or future earning capacity. She went through the trial court went through all of the various testimony that allowed her to arrive at the conclusion that the jury.
I understand, but besides, the judge maybe didn't believe her as much as the jury did, or maybe didn't like it. But when we're looking at this and deciding whether she abused her discretion, those three things jump out off the page as reasons that this judge highlighted that weren't really, one of them, they withdrew their objection and their motion. The other two were never objected to. So how is that not an abuse of discretion?
Yes, Your Honor, I understand your point. I think the idea is that a trial court, in determining whether a motion for new trial should be granted, outlines all of the various undertaking as far as what it considered and what it believes is in support of for its decision to ultimately grant a new trial, and an inclusion of detail and facts and testimony and evidence with regard to arriving at that conclusion. And it doesn't follow that everything that the court would draw out as to the basis for why it makes the decision is testimony or evidence that would have been objected to. Rather, the court is incorporating all of those things that the court believes may play a part in why the verdict is excessive.
Why would you say it's not then a due process violation at a minimum if the plaintiff didn't have a chance to even respond on the issue of the religious statements or Mike Deason's testimony?
Well, I think that to say that it's a sua sponte due process violation is probably akin to arguing that then you would have to object to so much more at trial that maybe isn't something that figures into the moment or the testimony or be particularly important. But in the scheme of things, when the trial court is looking at the totality of what happened at trial and all of the evidence in the testimony together and weighing it for whether it's against the manifest weight of the evidence, these are the issues that figure into the trial court's review
But the
Not
flip side
necessarily.
of your argument that they'd have to raise all the objections, which I would suggest that that is the trial counsel's job, is to raise these objections. But the flip side of that is to say that based on the facts of this case, two general references to somebody's religion or places that they go could serve as a basis to overturn a jury verdict. You know, coupled with some other things. I understand it wasn't just that, but to allow that to go as not being an abuse of discretion, wouldn't that invite future juries or future judges to bring up those kind of issues and never give a plaintiff an opportunity to even respond?
Well, I think that it goes to, if we think about the order or look at the order, all of the issues that the court raises in the trial, in the order granting a motion for new trial in this case, in theory, the plaintiff didn't have an opportunity to respond to any of those issues that the court raises, but rather the court picks out those particular details that the court believes may have impacted the verdict, that indicate maybe the jury acted with passion in reaching its conclusion.
But as you indicated, most of those were based on the plaintiff's testimony and other things that clearly they had a chance to control because it was her testimony. These other factors, the three factors I mentioned, are things that were either withdrawn or she didn't have a chance to respond to. So you can continue. I don't want to take any more time with it, but that's what I'm struggling with on your case.
Yeah, I recognize that, Your Honor, and I would simply say that I believe that the brief mention of those two issues, Mr. Deason and the religion, in the order, in Progressive's opinion, simply serve as as additional factors in light of all the testimony and evidence that the court lays out that figure into the overall determination of the excessiveness. The other thing that the court looked at in this particular case were recent decisions to arrive at its conclusion that the verdict was excessive, and the trial court reviewed 4 cases that had recently been tried in the same venue with very similar facts and defenses, and considered those cases.
But 2 of which didn't have a permanent injury finding.
Correct, Your Honor.
So you really only have 2 cases that are similar. This was a permanent injury finding.
Correct, Your Honor. A permanent injury with regard to the jury's ultimate conclusion. But if you look at the defenses and the actual injuries that were claimed, they're very similar from the onset of those cases. You
got about 30 seconds. Go
okay.
ahead.
The older cases that are recommended or from different jurisdictions shouldn't bear the same weight as those from the similar jurisdiction tried before the same juries in the same time frame. It's not unreasonable that a seasoned trial judge's conscience was shocked by the jury award in this case when the evidence showed that Ms. Maronek had not received 1 injection, had only received some of the recommended care and sporadically at that, and did not have a surgical recommendation. 96% of the future medical award was for pain management, which in the 4 years since the accident had not been any part of her treatment, despite recommendations starting less than 2 months after the accident. Ms. Maronek testified that the only activity she had not undertaken since the accident, which she engaged in prior, was rollerblading. And despite what appellant is encouraging this court to do, it's the trial court's responsibility to weigh the evidence, consider the credibility of the witnesses, and determine whether the jury has reached an unjust decision under the facts. If the trial court's actions were reasonable, then the order should stand, and the trial court's granting of a new trial here doesn't rise to the level of abuse of discretion. Thank you, Your Honors.
Thank you. Mr. Sider.
Thank you, Your Honor. I'd like to start with the argument that perhaps the trial court, although it did say that Dr. Gandhi's testimony shouldn't have been admitted because he relied on the database, that maybe the trial court didn't base any of its ultimate rulings here on that finding. Our argument is this was not dicta. These were not idle musings that the trial court decided to set out in the order. The trial court discussed the reliance on the database because it factored into the trial judge's decision-making. And if that isn't, self-evident enough by the attention that the court gave it, I think it becomes abundantly clear when you look at the actual legal ruling that the trial court made here. On page 168 of the record, the trial court says, applying the facts enunciated at the outset of this order, the court finds that the jury's award of future medical expenses was not a reasonable representation of the evidence. So the trial court saying, based on the facts that I set out at the beginning of this order, I find that the verdict as to future meds was against the manifest way of the evidence. So it's clear that the trial court did in fact base its ruling on those findings. And the same thing is true for this sua sponte issues having to do with Mr. Deason and the church issue. Again, the trial court didn't write these paragraphs for no reason. The trial court, not only for no reason, but unsolicited. The trial court didn't do that because it wasn't important to the trial court. The trial court clearly was bothered by it, and it factored into the decision-making here. Now, Mrs. Warden-Brooks suggested that, it's not fair because some of this stuff maybe wouldn't have warranted an objection, but they still want to raise it. They still want the trial court to be able to consider it post-trial. That is antithetical to the rules of preservation. If something doesn't warrant an objection, then it's not objectionable, and it can't be used as a basis for granting a new trial. And then the only other thing I wanted to mention is that this discussion of past treatment history that Ms. Warden-Brooks discussed today, and how there was some spotty treatment in the past. As you pointed out, Judge Sleet, this was squarely in front of the jury. It was a central issue in the case, and the jury did take this into consideration. It could not have missed it. And so the question becomes on appeal, was the evidence manifestly weighted in favor of Progressive on this? And the answer is no, it was not. That this was a disputed issue of fact, and the only way for the trial court to decide this case in Progressive's favor was for it to step in and act as a seventh juror. And for all these reasons, Your Honor, we would ask that the court reverse and order that the trial court reinstate the jury's verdict. And I'll rest now unless Your Honors have any further questions. Thank you. Judge Sleet, you're muted. I didn't know if you were asking me a question or not.
I'm on mute. That's the problem. We don't have any questions. Thank you. All right. If you could leave the Zoom meeting. Our next case, Hillsborough Insurance Recovery Center